In the matter of the state of Michigan versus Kevin Beard, 25-01648. Appearance, please.
Good morning, Your Honor. Haley Fortuna Gill on behalf of the people.
Good morning, Your Honor. Attorney Derek Petsch, also public defender on behalf of Mr. Beard, who is in the courtroom standing to my right.
It's Kevin Beard the second, correct? Today was the date scheduled for a preliminary examination. My understanding is that there's going to be a plea.
That is correct, Your Honor. The people are prepared to offer.
Have a plea sheet and device of rights.
It's a civil infraction, Your Honor.
Oh, okay. You're amending it to what?
Littering.
And you're accepting responsibility. Fine is $135. When can you pay? You pay today. We'll get you the criminal traffic window, and you'll be all set. Any additional matters for the record?
Nothing on behalf of the people.
Not from the defense, Your Honor.
Thank you. You're all set. This is the state of Michigan versus Dustin Griffin, 25-01288. Appearance, please.
Haley Fortuna Gill on behalf of the people.
Good morning, Your Honor. Jacob Sarks, the fourth assistant public defender here on behalf of Mr. Griffin. He's standing to my right.
Okay, Mr. Griffin, I was scheduled to have a preliminary examination today on a assault with intent to do great bodily harm, less than murder or by strangulation. And there's a DV second. How are we proceeding on this?
Your Honor, the people do not have the necessary witnesses to proceed.
Thank you, Your Honor. At this time, the defense would move to dismiss. Mr. Griffin understands that if Your Honor grants this motion, that this would be dismissal without prejudice. Thank you.
The motion to dismiss without prejudice is granted. The people can reissue this charge against you. Do you understand that? Do you have any questions? We'll get you a copy of the dismissal in just a moment. Thank you.
Thank you, Your Honor.
On the record in the matter of the state of Michigan versus Michael George Shelton, 25-01910. Appearance, please.
Haley Fortuna Gill on behalf of the people.
Good morning, Your Honor. Attorney Derek Petsch on behalf of Mr. Michael Shelton, I'm from the public defender office, and he's in the courtroom standing to my right.
That's Michael Shelton Jr., correct?
Yes.
Okay, today was the date scheduled for a preliminary examination. However, I've got a note that there's a request to adjourn so that he can hire private counsel.
Yes, Your Honor, that is correct. We're asking the court to accept the timeline waiver. Mr. Shelton has been in touch with Mr. Carter. I'm not sure if he's named Mr. Carter, but if he doesn't, he does intend to retain a different private attorney.
Okay, so Mr. Shelton, you understand that you have the right to have a preliminary examination within 21 days of the date that you are right. Okay, and so in order for me to adjourn this, I would need you to be willing to waive the timeline so that I can reset. Is that what you want to do? Okay. August 22nd at 9:30. August 22nd at 9:30. Do you have any questions for the court today? I'll get you a copy of your notice to appear. Any additional matters for the record, counsel?
Nothing on behalf of the people.
That's for a preliminary exam, Your Honor.
That's correct.
Thank you.
Thank you. You're all set. Can we bring up Jeffrey Evans? We're running Jeffrey Evans, correct?
That's my understanding, Your Honor.
And Floyd Rush is going to be a request to adjourn.
On behalf of the defense, that's my understanding.
Brenda Smith would be a motion to dismiss, Your Honor, and I'll waive her appearance. Brenda Smith.
Okay. Sean, can we bring up Floyd Rush?
Yes, sir.
On the record in the matter of the state of Michigan versus Brenda Smith, 25-01909 appearance.
Haley Fortuna Gill on behalf of the people, but Your Honor, I'm realizing now that I didn't make my motion to practice this morning yet, so I do have to make that motion under Michigan Court Rule 8.120. I have APA Abigail Tepper in the jury box here to my left.
Motion granted.
Thank you, Your Honor. I'll start.
All right. Your Honor, at this time, it's my understanding in regards to Ms. Smith's case that the required witnesses haven't appeared. I will be making a motion to request the court dismiss the case without prejudice. I would waive Ms. Smith's appearance here. She is here in lockup. We have had contact with her. Her adult protective service worker was here this morning and also went downstairs and talked to her in lockup.
Thank you. I wasn't sure if you stated your appearance for the record. I don't remember you stating your appearance for the record. She made her appearance in her
Oh, I'm
motion.
sorry, Your Honor. Your Honor, Attorney Derek Edson, also public defender on behalf of Ms. Smith. Ms. Smith is here in the building in lockup, and I would waive her appearance at this time.
Very good. And is that true that the prosecution does not have the necessary witness?
That is correct, Your Honor.
Motion to dismiss without prejudice is granted. I will get you a copy of the dismissal for the client. No problem. And she'll say you gotta use it.
Your Honor, I do believe that Lindsay Patton is going to run. I spoke with Mr. Milks. I know that he's jumping around. I do have the ATF officers here, but they have a search warrant later today, so I was hoping that could be the first exam that we run, if at all possible.
They're executing a search warrant in the middle of the day. So you don't.
That's what they told me, Your Honor.
Got it. The first time ever. Yeah, probably won't be the first one because Mr. Milks is not here.
This is the wrong one. I just spent 20 minutes trying to figure it out. Yeah, I was with them, so I can see. Okay.
Mhm.
We have two files for him, one of which, the file that is up today, with Buchanan. We have a notice in our PDK system that this court number was created on that same file. There is another file somewhere that has to do with the same incident that has heroin.
That was already, Buchanan already did.
Buchanan did the cocaine. We are supposed to have the heroin case today. That's from the
Okay.
same incident. One got issued immediately and then the other drug was sent to the lab.
Okay.
So the confusion, I think, and I can grab Melanie if I need to, but confusion is because this court file, at least in our system, has already been processed to circuit court. And then we got this particular file set for prelim and probably cross conference. Gene Kelly didn't have the right discoveries.
Okay.
And I don't know how to fix that.
Judge, the file for Evans, what is the complaint? Because it might be the same.
That's my concern, is because it came from.
Might be the same as what?
Another one of his files instead
That's
of
my
what it's
concern.
supposed to be. Is what I'm
What's
getting.
the
Okay.
other?
That's my concern.
What was the other case number? It was one that Buchanan already did.
Yeah.
I think it was 25-00889.
Do we have that file still?
No, it's over. It's
Yeah, I know. We were, I was like, I'm so
Charges.
confused. Yeah. There it is. Yeah.
Delivery manufacturer less than 50 grams of cocaine and habitual offender fourth offense notice on the new file does not have the fourth offense notice.
The new file doesn't have what?
Does not have the habitual offender notice.
You're talking about for Rush?
for Evans.
Evans.
Evans. Date of, what's the date of incident?
Still, I think it's that she said it was the same day. What is the date? on
December
28th?
2024.
Correct.
Yeah.
So we show that it was moved to Stoughton. We got
At Stabler and Holmes, controlled substance delivery manufacturer. Habitual offender for defense notice. Is on that. So the one that we-
so that's the one that should be in.
Because it already did a examine Buchanan on the
Correct.
cocaine he with.
I'm sorry?
They already did an exam in Buchanan on the cocaine he with that we have set for exam today. That I prepped for
So she
exam
did
today.
something else, is what this is.
Correct. We issued a separate charge.
Mhm.
Things were sent to the lab. And it was not ever consolidated. So I don't know if
I'm not really following. This, you're saying this is the same exact charges as the other charges that were already bound over,
correct.
but your intent was to issue separate charges?
We did issue separate charges. I think because it was the same plate number, there was confusion in the clerk's office. Is best that I can tell based on my end.
They were the same complaint number. How's it
They're the same report.
Because the cocaine that was found was true narc. So they ran that exam right away. There was also heroin found, but that had to go to the lab. And so
Okay,
that's.
so so the one we're looking for should be on heroin.
Correct.
Who? I'm trying to track down the actual complaint. Who signed it? Do we know?
Give me one moment and I pull it up.
Mr. Pfeiffer, I've not seen you in
I know,
a season.
I know, wait a minute.
It was signed by APA Makeover,
Do you know when?
June 4th, 2025.
Okay, so then it would have been over here.
Yep, so the advisory are down here. Just send
I'm just
it.
trying to figure out who would have signed it.
Don't grab the first one.
Like the judge was,
Yeah,
The first one looks like.
the
it's
one
same
that
as the
I'm
second,
looking
but It's
at,
not.
the one, the pending one. This is for
Flores filed the complaint. On what date?
No way.
Because
One of
we-
them's-
If they lost it, we just gotta go to his email and find it.
City attorney.
Okay.
We're not gonna run it today anyway. She needs
No,
to
it's
know
not.
how to register it. So I'm gonna let those officers go. Yeah.
I'll deal with it.
Thank you so much. Abby.
I got you.
It is not your fault. I will let you go first.
This one.
Yeah, at least the chaos is divided off this time.
No, it is.
Maybe milk some way.
I saw the response right through. I think,
What's on the way? Yeah.
I'm gonna be back here. Come see.
So the first one. Okay.
I read through the words.
Perfect. Yeah, add stuff, change stuff.
No, it's very.
Um, So,
Right.
but.
I just checked, oh, you can be seated. I just checked with the prosecutor's, with the clerk's office. The error was not on us. He also does the same thing twice. So he signed the same thing and Judge Fleur signed both, one in March, one in June, same exact complaint.
Okay,
So it's probably the officer that screwed it up, but
I will figure out what.
we gotta
happened.
track down that officer and figure out if he can send us the correct one. So that one's scheduled for an exam today,
That is correct, Your Honor.
because he would not have been arraigned. So let me see. He was arraigned again on the same exact thing.
And Ms. Vaughn, you wouldn't have a proper discovery, right?
And he told the officer who was arraigning him that that's the same charges.
Wonderful. Okay. And this is Mr. Evans, is that who this is?
That Mr. Rush.
Mr. Rush, okay, we'll deal with this one right now. On the record, in the matter of the state of Michigan versus Floyd Rush, 25-01911, appearance, please.
Haley Fortune Gale on behalf of the people.
Good morning, Your Honor. Melanie Watching from Mr. Rush, who's sitting at the council table.
Okay, Mr. Rush had a preliminary examination on assault with intent to do great bodily harm and the domestic violence third. Will we proceed today?
On behalf of Mr. Rush, I would like to ask for an adjournment. Both the alleged victim and my client believes that the business around where the incident may have taken place have the footage of the incident. Our investigator went there and they provide us with a video, but it was for no, was not for that day, the day of the incident. So we're still waiting for that video. For that discovery.
Okay, so you need some additional discovery.
Yes,
Your Honor, the people would request that we proceed with the preliminary examination. We do have all of our witnesses here, and it is my understanding that the surveillance footage that we are looking for wouldn't show the assault. It's my understanding after speaking with the officers, that the assault occurred on a trail where there were no surveillance cameras. And the surveillance cameras in question are in the parking lot of Pisano's, which is not where the assault occurred, according to what my witnesses tell me.
Oh, so she should just take what your witnesses said, right?
You know, the alleged victim said that, told us that the business.
You don't need to make any further. She doesn't have to take what the witness said. You got to turn over the discovery so they can review it.
We don't have that discovery at all, Your Honor.
Your witnesses have seen it.
I don't believe
How
so.
do they know what it shows then?
I don't. I just know that the assault occurred, the alleged assault occurred on a trail, a park trail, and with no surveillance cameras anywhere around, and that the surveillance cameras in question are the Pisano's surveillance cameras, which is not where the assault occurred. That's my understanding. That's all.
Okay, the allegations of the incident took place at 1825 North Grand River. That's correct.
That's what the complaint says, and that is correct, Your Honor.
And that's not a Pisano's. What is that? Is it near Pisano's?
I know that the trail is near Pisano's, so it's all near. That address is the address to Pisano's, so
That's the address to Pisano's?
that is, Your Honor.
They-
Understood.
They want to see footage from Pisano's. He's willing to waive the timeline for that purpose?
Yes, sir.
Case waived. August 28th at 8:30. August 28th at 8:30. Any additional matters for today's record?
Nothing on behalf of the people, Your Honor.
You're all set. Okay, back to Evans. I'm trying to see if I can track down which officer did this because
I'm also trying to look, Your Honor.
I can't read their handwriting on the affidavit of probable cause, and I believe they were the one who made the error. Ironically, Judge Flores signed most of these, but 3 months apart. He can be transported back. What do we have here?
We are ready to take a plea on Rio House. Scheduled for examination today at 9:30.
Okay.
Master Hospital,
I'm sorry?
you want Master Hospital?
Not exactly. Let me see here. What are we doing with Edwards?
Obviously, we have to-
Edwards.
Edwards.
Edwards,
Yeah.
Juanita Edwards. You,
She was transported to MTOC this morning.
okay, so she's not here. Okay, yeah, we can, I'll bring Rio herself.
Yes, sir.
Let's see here. On Evans. Detective Kramer, I believe, sent this over.
Okay. Officer Fox came too, but I think he's testifying. Okay.
He's here this morning as well. I haven't.
Yeah.
Not for
He
me.
says he's not.
I don't really know if Brian Kramer is with LPD or. Okay, on the record in the matter of the state of Michigan versus Xaviana Boland, 25-01. I'm sorry, I don't see Miss Robinson here. She's right there. Oh, there she goes. 25-01232, appearance, please.
Haley Fortuna Gill on behalf of the people.
Karen Robinson, Assistant Public Defender for Ms. Boland.
Have you had any contact with her?
I have not seen her today, Judge.
And you've not communicated with her since her plea?
I have not been able to get in touch with her, no.
Probably should be. And Winfrey is asking for an adjournment.
Yes, ma'am.
On the record in the matter of the state of Michigan versus Markel Winfrey 25-01645, appearance, please.
Haley Fortuna Gill on behalf of the people.
Karen Robinson, Assistant Public Defender for Mr. Winfrey.
Thank you. Ms. Winfrey was scheduled today for a preliminary examination on a police officer pleading the third degree under the penal code. There's a request for an adjournment.
Yes, Your Honor, we'd be requesting an adjournment due to some discovery that's missing. It looks like we're missing some of the body worn camera footage as well as the search warrant that's mentioned in the police report.
Okay, and Mr. Winfrey, you understand you have the right to have your exam today, which is within 21 days of the date that you were arraigned.
Yes, ma'am.
Are you willing to waive that 21-day timeline so this could be reset?
Yes.
So August 29th at 10.
August 29th at 10. Do you have any questions for the court, Mr. Winfrey?
I'm sorry, Judge?
Oh, I asked if you had any questions.
Oh,
Okay, any additional matters for the record?
no, Your Honor, thank you.
You're all set. Yeah, that was good. I guess there was a question I wasn't asked.
No, you're good.
He's getting Mr. Rivas. Mr. Mills.
Your Honor, how are you?
Oh, well, how are you?
Andy, thank you.
Are you covering for Freeman today?
I'm covering for myself.
Are you covering for Freeman? You can't cover for yourself. You are yourself.
That's fair. That's fair.
Details.
Outside of split personalities, you are absolutely correct. I am not aware if I'm covering for Mr.
It says that on mine, but I don't know where we got that information from. I'm not
I'm
saying it
sorry.
came from a reliable source.
No, for Mr. Arnold, yes, I am. I'm sorry. Yes, I am covering for
I was gonna
for him
say,
on that one. My
No, did you have your coffee today?
Not enough.
Okay, on the record in the matter of the state of Michigan versus Michael Arnold, 25-00111, appearance, please.
Haley Fortuna Gale on behalf of the people.
Good morning, Your Honor. Stephen Mills, covering for Mr. Freeman, as we just alluded to. For my client who is currently not here at this time for today's sentencing.
And we've not seen him today, is that correct?
That is my understanding, Your Honor. I give a picture of him. I didn't see him in the hallway. Speaking with court staff, Your Honor, they have noted that when this was scheduled at 9 o'clock, he's not been here. They've not seen him, despite calling for him.
I will say, he has a history of appearing late because he takes the bus. However, he was supposed to be here at 9, correct?
Just now.
And he's not here, so I'll hold to the end of the day, and then if he doesn't appear, I'll issue a bank.
Very gracious. We appreciate that.
And then we're running yours, is that correct?
Your Honor, yeah, we believe it's going to be a waiver.
Are you ready to do that now?
Yes, Your Honor, we're ready.
Okay, on the record in the matter of the state of Michigan versus Lindsay Patton, 25-00691, appearance, please.
Haley Fortuna Gale on behalf of the people.
Good morning again, Your Honor. Stephen Milks on behalf of Mr. Patton. Mr. Patton is present and staying to my right at this time.
Mr. Patton is scheduled for a preliminary examination on controlled substance delivery, manufacturing, 1, 2, 3, 4 weapons charges, and then felony firearm, 4 counts, and a habitual offender third offense notice. And he does not wish to have his exam today.
Your Honor, that is a correct statement, yes.
The people are waiving.
That is correct, Your Honor.
Is there an offer that you want to put on the record that it's
There is not, Your Honor.
And that is our understanding too, Your Honor.
Mr. Patton, you understand that you have the right to have a preliminary examination?
Yes, sir.
You understand the purpose of the exam?
Yes, sir.
You have the right to require that the prosecutor first establish that they have sufficient probable cause that each of the felonies you've been charged with were actually committed, and then probable cause sufficient enough to charge you as the person who committed those felonies. You understand that? You wish to unconditionally waive your examination?
Yes.
And no one's threatening you to do that, correct? No promises if you waive your exam?
Your Honor.
Find your matter to be freely and voluntarily waived. The matter will be bound over to the circuit court. Your bind over date is going to be the 30th of July. That's the date the circuit court gets to file. That's not a court date that you have to appeal for, okay? Your next court date will be a pre-trial in the circuit court. Your attorney will be made aware of that. So you need to stay in contact with your attorney. You understand that?
Yes, I do.
Has your number changed since your arraignment?
No, it has not.
And your address is still the same? Is it on Dunlap?
That's correct.
Okay. A bond was set at 5,000 personal recognizance that will continue. Any additional matters for the record?
Nothing on behalf of the people, Your Honor.
Nothing on behalf of the defense. Thank you, Your Honor.
You're all set. What's going on down there in the jail? Yeah, all right. Mr. Lee is on which matter?
Oh, Stein.
Vanessa Stein.
Yeah.
She's not here, but
Oh, yeah, you're right. Thank you.
Okay, Mrs. Riojas.
yes.
On the record in the matter of the state of Michigan versus Thomas Riojas, 25-01776. Appearances, please.
Yes, good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
And thank you, Your Honor, and good morning. Jared Austin appearing on behalf of Mr. Rio Haas. He is present with me at the table to my right.
Mr. Riojas is scheduled today for a preliminary examination, and then there is a bond violation hearing scheduled for today.
That is correct, Your Honor.
How are we proceeding?
Your Honor, the parties have worked out a misdemeanor plea agreement in this matter, and we would ask that, what we think would be most appropriate is for the bond violation matter to be held until the sentencing. As his compliance between plea and a sentence would probably affect how this court views what it wants to do for the bond violation. But I'll say anything that happens in the bond violation is independent of the plea.
What's the offer?
The offer is for the defendant to plead guilty to count 2, misdemeanor domestic violence, and an added count 3, misdemeanor domestic violence. The people would agree to 7694A if eligible, which the people, based on the criminal history, believe that he is.
That is my understanding of the agreement as well, Your Honor. And there is a plea agreement form that states that. And if I just may have Mr. Rio Haas sign the advice of rights, and if I may, then
Thank you.
work with that.
Okay, Mr. Rios, raise your right hand, please. You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury. Okay, this is an advice of rights and the information sheet. You understand each of the rights listed here? You understand that you have the right to take this matter all the way to jury trial. You have the right to maintain that you're innocent because you're innocent until proven guilty. You understand that? You have to waive your right to the presumption that you're innocent if you want to enter a guilty plea. Is that what you want to do? You also have the right to Maintain your silence at trial, not have silence be used against you. Your right to see, hear, or question any of the witnesses called to testify against you. You have the right to subpoena witnesses that will testify on your behalf, or you can waive your silence and testify at your trial. You understand that? Okay, and you wish to waive all of those rights to plead guilty to count 2 of domestic violence and the added count 3 of domestic violence. Is anyone threatening you to get you to plead guilty? You said no? Has there been any promises extended to you to get you to plead guilty? Are you currently on probation or on parole? You understand that by pleading guilty, it could result in a conviction that may have impact on where you can travel, or it could impact immigration status. It also could be a conviction that you may need to report to your current employer or a future employer. As to count 2 of domestic violence, how do you plead? As to the added count 3 of domestic violence, how do you plead? And is that because you believe you're guilty? Factual basis, please.
Mr. Riojas, taking you back to April the 13th of this year, were you at the location of 418 East Street in Lansing, Michigan? Was that here in Ingham County? And at that daytime and location, did you have contact with a Desiree Alvarez? And that's someone that you either were or had a dating relationship with?
Mother of my kids.
So you have children in common then? Okay. And at that daytime and location, there came a point in time where you became angry and there was an argument of some sort. Is that correct?
Okay.
And during that time when you were angry and having an argument, you placed your hands on Desiree. Is that correct? And you did that by pushing her or shoving her. Is that correct? And that occurred at least twice. Is that right? Satisfactory, Your Honor?
I have only one follow-up question. That's just to cover all the bases. Desiree didn't want you to push her, right? It was against her will. Nothing further. I believe that's sufficient factual basis.
Thank you. I'll accept your plea. I find your plea to be freely, voluntarily, and intelligently made. This matter is scheduled for sentencing September 11th at 9 a.m. You need to meet with our probation department so they can prepare a pre-sentence report and recommendation. They'll also advise me if you're eligible for sentencing under 769.4A.
Your Honor,
I'm
what was the
assuming
time?
9 a.m.
9 a.m. My
And
apologies.
no problem. I'm assuming you are being held on this one. Is that?
That is correct, Your Honor. He did have a bond. That bond was revoked pending the bond violation.
Any additional matters for the record?
Not in regards to the underlying charges, just the bond.
May I address bond, Your Honor? Thank you, Your Honor. As I stated, Mr. Riojas did have bond that was revoked upon the allegation of a no contact order. Mr. Riojas has resolved his case. The severity of the case has been reduced from a felony to a misdemeanor. He is gainfully employed. He's working. He has very nominal, if any, criminal history. I don't believe that I saw any prior criminal history that I could tell, Your Honor. So he's willing to be subject to GPS tether and monitoring, and if there's any type of increased restrictions on that, Mr. Riojas is willing to abide by that as well. So I would ask the court to consider either reinstating his bond or to granting him some type of reasonable bond.
Counsel.
Your Honor, I'm going to leave this to the court's discretion. He was arrested in the car with the victim the night before the PCC. I can tell you though, as of this morning, I looked and did what I do on cases. I did not see any type of contact or attempt to contact from the jail to the victim. It is my hope that he has learned his lesson. But again, I leave it to the court. I do think in regards to actually handling the violation itself, I think it would be best left for the 11th, but it is not my violation, it is the court's, so. The court.
troubling that there could be a arraignment on the 29th and conditions. Pretty simple, not to be within 2,000 feet of a person where the allegations were that you strangled, beat, and drugged the person. That is the mother of your 3 children, or 3 of your children, I don't know how many you have. And allegations that less than 2 weeks later, you're picked up inside a vehicle with that person in violation of the bond. So that doesn't send a message to the court that you could care about the bond conditions.
I don't think, it was, like you said, I have 3 kids with her and it was from my son, he was sick.
Well, yeah, I don't want you to say too much back about the violation.
Recognize you believe that you have a reason why you can skirt around or violate the bond conditions. It's still a concern. But the bigger concern is that you have 2 now convictions for assaulting someone who bore your children. That's the bigger issue. I am at least relieved to hear that Mr. Pfeiffer didn't find any attempts for you to violate while in custody. I hope that not only have you learned your lesson about that, but that you're figuring out now that you have no business putting your hands on someone's daughter. And it's a cowardly act. And it's not how you communicate or work through issues. And that's not an example you should be setting for your children. Because if you haven't learned that lesson, you'll have to learn some harsher lessons behind bars. I'm going to grant the request to reinstate the bond. He was on bond with GPS tether. I'm reinstating it to bond with GPS tether. I'm still going to hold open the violation until the time of sentencing. You need to report to our probation department by tomorrow, okay, in person, so that they can get you scheduled for your pre-sentence interview, okay? Do you have any questions about what you need to do?
When I get back to Mason, they just put the 10 on and I go.
They should be processing you to be released
I gotta
today.
pay again.
You have to pay the cost of the tether unless you're indigent and someone else is paying it.
Do you know the cost of it?
I'm sorry,
You know the cost?
I do not know the cost. No problem. Any additional matters for the record?
Not on behalf of the people, Your Honor.
I have nothing additional back, Mr. Riojas, Your Honor. Thank you.
Thank you. You're all set.
Thank you, Your Honor.
Someone else needs to be brought up. That person's not here. Ms. Schroeder, you have a plea with Felicia.
Actually, based on my conversations with Ms. Fortuna Gill, it appears that's actually going to be a motion of defense for discussion.
Did you want her brought up or are you waiting her appearance?
I would, if she, I can waive her appearance, I'm sorry.
It's up to you. She can be brought up. You're taking him back down right
Oh,
now.
yeah, if we can, if it's not gonna.
Okay,
yes,
please
please.
bring her up.
Thank you, Your Honor.
No problem. Not resolve the mystery of Mr. Evans yet. We'll bring it up, Lindsay. We did rush, correct? Yeah. Arnold failed to appear. Edwards, have a good one. Thank you. Edwards is in NDLC, so I gotta find.
August 29th at 10.
Yeah. Mr. Lee, you're ready with Stein?
Yes, ma'am.
Are we running?
No.
On the record in the matter of the state of Michigan versus Vanessa Rose Stein, 25-01926.
Haley Fortuna, sorry, Your Honor. Haley Fortuna Gill on behalf of the people.
Assistant Public Defender John Lee on behalf of Vanessa Rose Stein.
Ms. Stein has a police officer assault preliminary examination scheduled for today. How are we handling this?
Your Honor, the people do not have the necessary witnesses required to proceed on this matter.
This is a witness and officer.
That is correct, Your Honor. And that's not the only one on this docket.
Given that the people are unable to proceed, Your Honor, the defense would make a motion for dismissal.
Who is the officer?
The officer is Haven, Officer Haven. On this one.
Motion is granted. Case is dismissed without prejudice. The people do have the right to reissue the charge against you. Do you have any questions? We'll get you a copy of dismissal in just a moment. Okay, well, I think that's all we got except for, looks like, wow, you're a person coming up. And then that's all the felonies I got. Figure out if we can, I'm assuming that the
We're gonna-
detective did not come back.
We're gonna dismiss this file and figure out what's going on.
They're talking about Evans, right?
Yes, this is.
Yeah, well, what's going on is he sent the wrong thing to right to us.
You can give it to her.
You know, like,
Yes, and John. And this is the one. With the. This is Max. Okay, but I think so. She's not like that. This one is the one that I just showed. Adam. What's his name? I'm not sure what happened with all the pictures.
Okay.
I'm gonna ask again.
Yeah.
I think we're done. No, we have to, we're waiting for them to bring up this defendant, but it's gonna be dismissal. Okay, so we're almost done. Yeah. Since I spent. Figure it out.
Let's see if we can do the conclusion, I guess.
Sorry.
No.
Ms. Pepper?
Nope, you're good. You actually know it, but-
I'm excited to see that jury trial. Is he vital? Okay, so, no.
That's my understanding.
Oh, gosh, help us. Jesus. Okay. Okay, on the record, in the matter of the state of Michigan versus Felicia Valenzi, 24-01299, appearance, please.
Haley Fortuna Gill on behalf of the people.
And Assistant Public Defender Aaron Schroeder on behalf of Ms. Lindsay, who's present, now stands to my right.
Thank you. And Ms. Lindsay was scheduled to be here today for a preliminary examination for police officer assault. Is this the other one you were talking about?
That is correct, Your Honor. This officer is not present today, so we are unable to proceed.
It kind of goes without saying, but I'll say it anyway. Given that information, the defense would be moving for dismissal. Thank you.
Your motion to dismiss is granted. The people do have the right to reissue this against you, okay? Do you have any question?
Any questions? I may real fast, Your Honor, just to explain. So if, for whatever reason, the officer can be questioned, this is something you're gonna do here today, they might be issued, but this is the only thing holding you, yes.
Sounds really slim, considering the officer failed to appear, but it could happen.
Yes, absolutely. Yes, as long as nothing else is holding you in ICJ, you will be able to go home. I believe it.
All this long after they able to come. It's from 2024.
Same.
I think there was some confusion and some things, but we've gotten here, so thank you.
Maybe
Your
there
Honor.
was drone training up north.
You should be good to go. Okay. Oh, thank you. Is this for me or?
For your client.
Oh, my client. Thank you very much. Oh, you gotta go downstairs, you gotta come back to the gym, get dressed out, and all that stuff.
You're welcome.
But yeah, hopefully by this afternoon, you'll be able to make a phone call. Yeah, that's the paperwork that shows the distance.